Hello, welcome to this Kaplan Masterclass. We today are looking at insolvency. My name is Harry Gerling, and I work for Kaplan Financial as a tutor. Insolvency is a massive topic. Within the accounting law syllabuses, really they only really kind of scratch the surface. It's a huge topic area on its own. Law syllabuses within the accounting courses tend to concentrate on the difference between liquidation and administration, as well as maybe looking at the different types of liquidation. So we can have a voluntary liquidation, and we can also have a compulsory liquidation. So the objectives of this little masterclass is to explain to you the difference between liquidation and administration, and also to point out the differing types of liquidation that we can have. So let's start by looking at liquidation, in particular voluntary liquidations. First thing to say is what a liquidation is. Now, a liquidation, we are looking at a formal process of ending a company's life. Now, if you're a sole trader, if you're a partnership, you don't have to go through these formal proceedings. You can simply stop trading and notify HMRC. But for a company, there are far more formal proceedings. You can have, as I was saying, voluntary or compulsory liquidation. And we're going to have a look at the differences between these two types of liquidation. Our voluntary liquidation is where essentially our shareholders pass a resolution to go into liquidation. The default resolution is a special resolution. From earlier on in your law studies, you will probably have come across a special resolution. It's within most of the law syllabuses on accounting courses. A special resolution, you need 75% of the shareholders to vote in favour of the resolution. That will be the default resolution that's required. You can also pass an ordinary resolution if the period fixed for the duration of the company has expired, or if there's an event that has occurred within the articles that provides that the company should be wound up. And ordinary resolutions, you then only need 50% of the shareholders voting in favour. So 75% for the special resolution and 50% for the ordinary resolution. Now, within the voluntary liquidation, we have two different types of voluntary liquidation. If the company is solvent, we're looking at essentially a members' voluntary liquidation. That's when our shareholders have decided to put it into liquidation, even though the company's in good financial health. The definition of solvency is, generally speaking, seen as being able to pay all debts within 12 months. Now, the creditor's voluntary liquidation is where the company is insolvent. And insolvency is seen as being where you are unlikely, where a company is not likely to be able to pay your debts. Within 12 months. There are some procedures that you have to follow when you go through the members and the creditors voluntary liquidation. The big difference is that when we have the members voluntary winding up, voluntary liquidation, there has to be a declaration of solvency by the directors, who are essentially stating that they are of the opinion that the company will be able to pay its debts within 12 months. Making a false declaration is considered a criminal offence, and this must be made not more than 5 weeks before a resolution to wind up is passed and delivered to the registrar within a couple of weeks. You will then find that winding up commences from the passing of the special resolution. Well, usually special resolution, I guess it could be the ordinary resolution as we previously discussed. The members will appoint a insolvency practitioner to basically act as liquidator by passing an ordinary resolution to appoint the insolvency practitioner. And this liquidator will be responsible for realising all the assets and distributing the proceeds. Obviously, in this occasion, we're assuming that we are solvent and we are in good financial health as a company. And the liquidator will present their final report to the final meeting of the members and will inform the registrar of the final meeting, submitting a copy of their reports. And it takes about 3 months approximately to do all of this. Okay. We've then got our creditors voluntary winding up. Now, interestingly, it is still a special resolution passed by the shareholders. So this is an area that does confuse students. Even though we're looking at a creditor's voluntary winding up, it is still a special resolution passed by shareholders. But the big difference is there's not this declaration of solvency. The thing to remember is members voluntary winding up, you're looking at a company in good financial health that is solvent. A creditor's voluntary winding up, you are looking at a company that's not in good financial health, that is essentially insolvent. Once this special resolution has been passed, the members will appoint a liquidator. They'll give notice to the creditors who have a decision to make on whether they're happy with the choice of the liquidator. The directors also need to send to the creditors a statement of the company's affairs within 7 days. The creditors can approve the liquidator either via virtual meeting or by deemed consent process. And what basic deemed consent process involves is that unless 10% of the creditors of the company object to the proposed liquidator, then consent has been deemed. Note, shareholders and the creditors can appoint up to 5 persons to serve on a liquidation committee, and they'll basically be liaising with the liquidator. Again, liquidator is responsible for realizing as many assets as possible, obviously bearing in mind this time the company isn't quite in as good a financial health. So there may not be, I guess we'll come on to the order in which proceeds are distributed a little bit later in this masterclass. So there may not be available, there may not be that many proceeds available in this circumstance where we're insolvent. Again, this process does take approximately 3 months. So that's our types of voluntary liquidation. One thing that's important to understand is the difference between a voluntary liquidation and a compulsory liquidation. The compulsory liquidation, key thing to note, is ordered by the court. There'll be a petitioner for a winding up order that is presented to the court. Be listened to by a judge, and the judge will then pass an order that the company is to be wound up. There's lots of reasons set out in the Insolvency Act 1986, section 122. The main ones that you will need to know as far as your law syllabus is concerned is that a public company have not been issued with a trading certificate within a year of incorporation. One of the other main reasons is that a company is unable to pay its debts. This is theoretically considered if a creditor is owed at least £750 and has served a written demand for payment, and the company has failed to pay the sum due within 3 weeks. Now, in reality, guys, you're probably aware from your law studies that there's an enormous amount of court pressure. There's a big backlog with the courts, and it takes an enormous amount of time, effort, and money to take a case to court. And therefore, you would have thought it's going to take a lot longer, a lot more money than £750 and 3 weeks to actually get a case to go to court. And I would have thought lots of hoops and hurdles, efforts would have been attempted before a situation like this even becomes close to going to court. It could also be maybe you've got some shareholders at loggerheads and they're just not deciding on a way forward. Maybe you've got 2 or 3 different shareholders in a company, and they've just fallen out, and there's absolutely no way the differences can be resolved. The court might decide it's just equitable to wind the company up. This will only be the case if there is no other remedy available. Various petitioners for a compulsory liquidation. DBEIS, you're probably wondering what that stands for. Basically, a government department, a department for business, energy, and industrial strategy. That's what we're looking at there. Could be a shareholder, if you're looking at the just and equitable winding up. provided they've been a shareholder for at least 6 of the last 18 months. And obviously a creditor who's owed £750 that we discussed. With the winding up, it has the following effects. Any actions for recovery of debt against the company are halted. Floating charges, which you would have come across elsewhere in your law syllabus, they will crystallize. So they basically become more important, and the value is attached to the charge. Any other legal proceedings against the company are stopped, and none that have yet to start may begin unless obviously the court get involved. The company will cease to carry on business apart from literally completing the winding up, and the director's powers come to an end, although technically are still considered a director. And employees are sadly obviously made redundant unless a liquidator re-employs them to help complete the winding up. Now, with these subsequent procedures for the compulsory liquidation, you will have an official receiver that becomes liquidator. Within 3 months, the official receiver will summon some meetings of the contributories in order to appoint a licensed insolvency practitioner to take over the job of the liquidator. Again, we've got this deemed consent process that we just talked about a few moments ago. You can use a virtual meeting to resolve this situation. Again, liquidator is responsible for realizing assets, distributing proceeds, and the liquidator will return to the court, passing a court order dissolving the company. And again, what will happen? Liquidator will file a report, and then the company is dissolved from the date of the order. One thing that is important and commonly tested in law exams is the order that debts are repaid on a liquidation. You are always going to repay fixed charge holders first. So these might be lenders that have security over non-current assets, such as buildings. It will be on particular assets, and then if the company defaults on their debt, the fixed charge holder can essentially reclaim the asset that they're lending to the company. After that, you're going to have the liquidator's fees. You're then going to have your preferential creditors. So you're really looking at employees here. So employees take priority before we start looking at any other creditors. Recently, I think it was at the end of 2020, this legislation got announced. We've also come across or introduced, an act was passed, introduced this idea of secondary preferential creditors. And I think the idea here, the reason it's passed, was obviously PAYE for employees and national insurance for employees, and VAT paid by customers is obviously collected by the company. Now, in theory, that should be passed on to HMRC. That money collected from employees, from customers, shouldn't therefore be passed on to creditors to pay their debts. Instead, it should go to HMRC first. So yeah, that was so HMRC. They're now a bit higher up this application of assets, this creditor hierarchy, than they were historically, and that changed about 2020. You then got your floating charge holders, who have priority above unsecured creditors, who rank equally amongst themselves. And before you get to your shareholders, any sort of bank overdraft or loan interest should basically be paid off, especially that accrued during the liquidation. Now, if the company is insolvent, it's probably unlikely you're going to get down to this stage, guys. But if the company is solvent, then you're going to have preference shareholders that will claim some of their money back as much as possible if the company is obviously in good financial health. And then the last to be repaid, who are highly unlikely to get any money if the company, or any or much money at all if the company is insolvent. The last to be repaid will be ordinary shareholders. Now, if the company is in very good financial health, they're going to get quite a nice little surplus. But if the company isn't in good financial health, then obviously ordinary shareholders will lose out. But yeah, I'd say probably unlikely to get this low unless you're looking at a voluntary liquidation where the company is solvent. Okay, so that is liquidation. We then need to compare this to administration. So the big difference between an administration and liquidation is liquidation with formally ending the life of the company. Administration is a rescue plan. So we're trying to rescue the company so that it may continue trading as a going concern. We're going to appoint an insolvency practitioner, also known as an administrator, to manage the business and the assets of the company. And why are we doing this? Well, we're trying to keep the company trading as a going concern. So we're trying to rescue the financial difficulties the company is having. We're trying to achieve a better result for the creditors than would likely be achieved if the company were to be wound up. If the company is going to be wound up, creditors probably aren't going to get all their money back if the company's in big financial difficulties. But, you know, in an administration, if we can rescue the company, if we can do some restructuring or find some new investment, they might get all their money back, or at least quite a high percentage of their money back. And they, you know, that's going to be a better result. I would also probably say for employees' perspective, you know, some of them, if the company is liquidated, might be made redundant and go on and find as good work or even better work. But for a lot of employees, it's going to be a real struggle if they're made redundant. And so it's probably going to achieve better result for many employees as well as creditors if the company carries on trading, if it is possible. And again, what you might be trying to do with administration is to find some way of paying back secured or preferential creditors. Who can appoint the administrator? Well, it could be by the court, it could be by the company or its directors, or it could be by the holder of a floating charge over the company's assets. Now, if you think about administration, and there's loads and loads of examples of companies that have been into administration, come out of administration, and been very successful following the administration. I'm a big Southampton fan. We went into administration in 2009. We got relegated to League One after a pretty terrible 4 or 5 years. However, we are now, we managed to get in some investment. We managed to get in a buyer. A Swiss family came in and rescued us. And after a few years, I think about 3 years, it took us to climb back up to the Premier League. We've been in the Premier League for the last 10 years. I think it was our 10th year in a row in the Premier League this year. So that's brilliant. And obviously, there's a lot of examples of other football clubs. Leeds have had a pretty successful 3 or 4 years. They're one of the bigger Premier League clubs. Obviously, going into administration, I think in the early the early noughties, I think that might have been when Leeds went into administration. Again, they had some difficult times, but now they're fighting back in the Premier League, doing very well. You've got a couple of examples on the high streets. Clinton Cards, they've been into administration twice in the last 10 years. In 2012, they went into administration, and also in 2019, they went into administration. Again, the idea with these administrations to find some new investments, to find some owners, to protect some jobs, to find a better result for the creditors than doing a formal winding up. The consequences of administration is that the company goes into a moratorium period during which any rights of creditors to enforce security over the company's assets are suspended. No other legal proceedings can be commenced. You can't pass any sort of voluntary winding up of the company. The directors will still continue in office, but their powers are suspended. The administrator, he will take over essentially the role of the directors as a company's agent, and he has a duty to act in the best interests of all the company's creditors. So he takes on the powers previously given to directors. So they're in charge of managing business and the company's assets and property. So they can sell some assets, borrow money if they need to help run the company. Again, you can have a deemed consent process for this administrator appointment. And the aim of administration is that it must normally completed within 12 months of the commencement date. If it's likely that extending this by a month will achieve the desired result, then they do have the ability, courts do have the ability to extend this period, or a majority of creditors agreeing that a small extension would likely achieve the desired result. That, my friends, brings us to the end of this insolvency masterclass. Hopefully, you guys are all okay and understand that liquidation, we are looking at a formal ending of the company's life. Administration is an attempt to rescue the company. And we've got our voluntary liquidation, which can either be when we're solvent or when we're insolvent. Insolvency means we're unable to pay our debts. Solvency means we're able to pay our debts. And you're happy that a compulsory liquidation is an order by the court. Thank you very much for listening, guys. All the best, and hopefully see you all again. Take care, and thank you for listening.